The conference room felt suffocating. I watched Diana Fletcher present my legal strategy to the managing board, slide by slide, argument by argument. Every patent claim construction I had drafted, every prior art analysis I had developed, every litigation tactic I had conceived during months of intensive legal research. She stood there in her tailored Chanel suit, gesturing confidently at the projection screen, while I sat in the back corner, invisible. This patent portfolio defense represents a sophisticated approach to invalidity arguments, Diana announced, her voice steady and authoritative. I've spent the last 16 months developing this strategy, analyzing thousands of prior art references and constructing arguments that will withstand Federal Circuit scrutiny. My hands clenched under the table. 16 months. The exact timeline matched perfectly. 16 months since I had first shared my breakthrough legal approach with her in what I believed was a confidential strategy session. 16 months of watching her strip away my contributions piece by piece, repackaging my legal innovations as her own brilliant advocacy. But Diana Fletcher had made one critical mistake. She hadn't counted on me being an attorney who understood the value of documentation. Every email, every legal memo, every client communication, every billing entry had been meticulously preserved. And in exactly 72 hours, I would present the firm's ethics committee with irrefutable evidence that would end her legal career permanently. Before I tell you how I systematically destroyed the woman who stole 16 months of my legal work, I want to invite you to subscribe to The Reckoning. This channel is dedicated to stories of brilliant professionals who refused to let theft define their careers. If you believe that legal expertise should be credited to its true creator, hit that subscribe button. You'll want to see how this ends. My name is Rachel Morrison, and I've wanted to be a lawyer since I was 16 years old. Growing up in Sacramento, California, I was the daughter of a paralegal and a community college professor. My mother, Susan Morrison, worked at a small personal injury firm, handling case files and legal research for attorneys who often took her work for granted. My father, Robert Morrison, taught political science at Sacramento City College, inspiring students who couldn't afford university tuition. We lived in a modest 3-bedroom house in the Land Park neighborhood, solidly middle class but always conscious of money. My parents had both worked their way through college without family support, and they instilled in me the value of education and self-reliance. My mother would come home exhausted from long days at the law firm, but she would still help me with homework and tell me stories about the cases she worked on. I became fascinated with intellectual property law during a high school debate tournament when I was 16. The debate topic that year involved patent reform, and I spent months researching the patent system, learning about prior art, claim construction, and the balance between innovation incentives and public access to knowledge. The complexity appealed to me, the way technical innovation intersected with legal frameworks to create property rights in ideas themselves. My mother noticed my interest and brought home patent applications and legal briefs from her firm's occasional IP cases. I would study them for hours, analyzing the legal language and understanding how attorneys constructed arguments to protect inventions. By senior year, I had decided definitively that I wanted to become a patent attorney, combining legal expertise with technical knowledge to protect innovators. My parents supported my ambitions but were realistic about the challenges. Law school was enormously expensive, and patent law required technical expertise that meant years of education before I could even begin practicing. My father sat me down during my senior year and explained our financial situation with characteristic honesty. Rachel, your mother and I will help however we can, but law school costs hundreds of thousands of dollars. You'll need scholarships, you'll probably need significant loans, and you'll need to work throughout school. Patent law is competitive and demanding. Are you absolutely certain this is your path? I was certain. I had never been more sure of anything. I told him I would do whatever it took, work as many hours as necessary, take on whatever debt was required. The path would be difficult, but I couldn't imagine doing anything else. I worked relentlessly through high school, maintaining a perfect 4.0 GPA while working 20 hours per week at a copy shop near the state capitol. I took every advanced science course available because patent attorneys needed technical backgrounds. I volunteered at legal aid clinics, shadowing attorneys and learning courtroom procedures. My social life was nearly non-existent, but I was building the foundation for my future career. I was accepted to UC Berkeley for undergraduate studies with a substantial scholarship, majoring in bioengineering with a minor in computer science. The technical training was essential for patent law, as attorneys needed to understand the inventions they were protecting at a deep level. Berkeley was intense but exhilarating. I joined a synthetic biology research lab in my sophomore year, working under Professor James Chen on CRISPR gene editing applications. The lab work taught me how to read scientific papers, understand experimental methodology, and communicate complex technical concepts clearly. I published 2 research papers as a co-author during my junior and senior years, giving me first-hand experience with the invention disclosure process that would later become central to my legal career. I was accepted to Stanford Law School with a financial aid package that made attendance possible, though I still needed to take out substantial loans. Stanford was a different world from Berkeley's engineering labs. The pace was relentless, the competition intense, the Socratic method in classes designed to break down confident students and rebuild them as legal thinkers. I excelled in intellectual property courses, finding that my technical background gave me advantages over classmates who struggled with patent claim interpretation and prior art analysis. During my second year, I secured a summer associate position at Morrison & Fletcher LLP, a boutique intellectual property firm in San Francisco with an impressive client roster of biotech and software companies. The summer associate's HIP was a revelation. I loved the combination of technical complexity and legal strategy, the adversarial nature of patent litigation, the satisfaction of protecting genuine innovations. The firm offered me a full-time position starting after graduation, with the understanding that I would sit for both the California bar and the patent bar examinations. After graduating from Stanford and passing both bar exams, I joined Morrison & Fletcher as a first-year associate. The firm occupied 3 floors of a modern building in San Francisco's financial district, with floor-to-ceiling windows overlooking the bay. The firm had 47 attorneys, all focused exclusively on intellectual property, representing clients ranging from early-stage startups to Fortune 500 technology companies. The work was demanding but intellectually satisfying. I spent my first 2 years learning the fundamentals, drafting patent applications, conducting prior art searches, preparing office action responses, supporting senior attorneys in litigation matters. The hours were long, typically 70 to 80 hours per week, but I was building expertise in a highly specialized field. Diana Fletcher was one of the name partners, having co-founded the firm 12 years earlier. She was 44 years old, with a reputation as a brilliant litigator who had won major patent cases in district courts and before the federal circuit. Diana had graduated from Harvard Law School, clerked for a federal circuit judge, and spent 10 years at a large firm before launching Morrison & Fletcher with her co-founder. During my 3rd year at the firm, Diana began working with me directly on a complex patent litigation case. Our client was a biotech company called GeneSynth that had developed novel gene therapy vectors, and they were being sued for patent infringement by a larger competitor. The case involved highly technical scientific issues and potentially hundreds of millions of dollars in damages. Diana was impressive in action. She understood patent law at a deep level, could deconstruct opponents' arguments with surgical precision, and presented compelling narratives to judges and juries. Working with her was an intensive education in high-stakes patent litigation. We would spend hours in conference rooms analyzing prior art references, constructing claim interpretation arguments, and preparing for depositions. I was promoted to senior associate in my 4th year, with increased responsibility for case strategy and client management. My technical background proved particularly valuable as the firm's biotech practice expanded. I could engage directly with scientists and engineers, understanding their inventions at a molecular level and translating that understanding into effective legal strategies. The first incident occurred about 18 months after I became a senior associate. I had been developing a novel litigation strategy for a patent validity challenge. Our client, a genomics company called Biogenics, was defending against infringement claims involving CRISPR technology patents. The case was high profile, with significant implications for the entire gene editing field. The traditional approach to patent invalidity arguments involved finding single prior art references that disclosed all elements of the claimed invention. But I had developed a more sophisticated strategy that combined multiple references in non-obvious ways, using scientific principles to show that the claimed invention would have been obvious to practitioners in the field at the relevant time. The strategy required deep understanding of molecular biology, statistical analysis of publication patterns in the scientific literature, and creative legal argumentation about motivation to combine references. I spent 3 months developing the approach, analyzing hundreds of scientific papers, interviewing experts in CRISPR technology, and drafting detailed legal memoranda outlining the strategy. I presented my strategy to Diana in a 2-hour meeting in her office. Her office was spacious with a view of the Golden Gate Bridge, walls lined with law books and framed certificates documenting her achievements. I walked her through every aspect of the strategy, using a whiteboard to diagram the prior art combinations and explain the scientific principles that made the obviousness arguments compelling. "This is exceptional work, Rachel," Diana said when I finished, reviewing my legal memoranda carefully. "This approach is genuinely innovative. Let me think about how we position this with the client and integrate it into our overall litigation strategy. Keep this confidential for now, just between us, while I determine the best timing for implementation. We don't want opposing counsel getting wind of our strategy prematurely." I agreed without hesitation. In litigation, strategy confidentiality was crucial. Telegraphing your arguments to opponents gave them time to develop counter-arguments. I returned to my office and continued refining the legal research, trusting Diana to handle the strategic positioning with the client. 4 weeks later, Diana presented at the firm's quarterly partner meeting. These meetings were where partners shared significant developments and strategic insights with the broader partnership. I wasn't invited as a senior associate, but I heard about the presentation from other associates who had attended. Diana had presented a novel approach to obviousness arguments in patent litigation, describing the exact strategy I had developed. She characterized it as her innovative thinking about how to approach CRISPR patent validity challenges. My name wasn't mentioned. She claimed to have spent months developing the approach, studying molecular biology literature and consulting with scientific experts. When I learned about this from a colleague, I felt physically sick. I went directly to Diana's office the next morning. "Diana, I heard about your partner meeting presentation. The obviousness strategy you presented, that was the approach I developed and shared with you last month." She looked up from her computer, her expression neutral. "Rachel, you're a talented associate, but you need to understand how law firms work. Junior attorneys develop legal research and analysis, but partners synthesize that work into client-facing strategies and take responsibility for implementation. Your research was valuable, but the strategic positioning and risk assessment that makes it viable in actual litigation requires partner-level judgment. This is how legal expertise develops through mentorship and collaboration. But you presented it as your own original thinking. You said you had spent months developing it when you actually spent 4 weeks reviewing my work that took me 3 months to create." Diana's expression hardened. "Rachel, attribution in law firms isn't like academic publishing. Partners take credit for work product from their teams because they bear ultimate responsibility for outcomes. If this strategy succeeds, the firm and client benefit. If it fails, I bear the malpractice risk. That's the nature of partnership. If you have concerns about compensation or advancement, we can discuss that in your next performance review." The dismissal was clear. I left her office feeling confused and betrayed. Part of me wondered if she was right about law firm culture. Maybe this was how things worked, with associates doing the detailed work and partners receiving credit for strategic vision. But it felt fundamentally wrong. I had created something genuinely innovative, and Diana had claimed it as her own. I tried to rationalize the incident and focus on my work. Maybe recognition would come eventually through promotion and increased responsibility. I told myself that the work itself mattered more than individual credit. But the resentment lingered, a sense that I had been robbed of something I had earned. The second incident occurred 3 months later. I had been cultivating a potential client relationship with a startup called Neural Tech that was developing brain-computer interface technology. I had met their CEO, Dr. James Park, at a biotech conference where I presented on patent strategies for neurotechnology companies. We had stayed in touch, and I had provided informal advice as their technology developed. Neural Tech was approaching a point where they needed serious patent protection before seeking Series A funding. Their technology was revolutionary, involving novel electrode arrays and signal processing algorithms that could decode neural activity with unprecedented precision. James had indicated they were ready to hire patent counsel and that he was impressed with my technical understanding of their innovations. I mentioned the potential client to Diana during one of our regular case status meetings. I've been developing a relationship with Neural Tech, a neural interface startup. They're ready to engage counsel for patent prosecution and strategy. The engagement could be worth several $100,000 annually and could grow significantly as they scale. Diana's interest was immediate. That's excellent business development, Rachel. Neurotechnology is a hot area. Let me join you for the pitch meeting with their CEO. Having partner involvement will strengthen our proposal and give them confidence in our firm's commitment. I was pleased that Diana wanted to support the pitch. Having partner participation would indeed strengthen our credibility. We scheduled a meeting with James and his technical team at Neural Tech's office in Palo Alto for the following week. The meeting went well. I presented our firm's capabilities and outlined a comprehensive patent strategy for Neural Tech's technology. Diana added comments about our litigation experience and track record with similar clients. James and his team seemed impressed and indicated they would make a decision within 2 weeks. 3 days later, I received an email from James. Rachel, thank you for the presentation last week. We've decided to engage Morrison & Fletcher for our patent work. However, Diana will be our primary contact partner. She reached out separately and suggested that having partner-level attention from the start would be more appropriate given the strategic importance of our patent portfolio. We appreciate your initial outreach and hope you'll still be involved. I was stunned. I went immediately to Diana's office. Diana, I just heard from Neural Tech. Why are you listed as the primary partner when I developed this client relationship over 6 months? Diana looked up calmly. Rachel, I think there was a miscommunication. When you mentioned Neural Tech, you described them as a potential client you had met at a conference. I understood that to mean they were an early-stage contact, not a fully developed relationship. After our pitch meeting, I followed up with James to ensure we converted the opportunity. During that conversation, he indicated he would be more comfortable with partner-level involvement given their company's stage and strategic needs. I agreed to serve as primary partner, with you continuing to provide technical support. That's not what happened. I cultivated this relationship for months. I provided technical advice, built trust with their team, and positioned our firm as their preferred counsel. You swooped in at the last minute and claimed the credit and the billing relationship. Diana's tone became sharp. Rachel, you're being dramatic and frankly unprofessional. Business development requires both cultivation and closing. You identified an opportunity, which is valuable, but I secured the engagement by providing the partner-level commitment they required. If you continue to make accusations about credit allocation, we'll need to have a more serious conversation about your judgment and fit with the firm. The threat was clear. Pushing back further would mark me as difficult and potentially damage my partnership track. I left Diana's office feeling powerless and angry. This wasn't about organizational hierarchy or appropriate credit allocation. This was theft of client relationships I had built through months of careful cultivation. The pattern continued and accelerated over the following year. Every significant legal strategy I developed, Diana would absorb and present as her own thinking. Every client relationship I cultivated, she would take over as primary partner. Every successful case outcome I contributed to, she would claim primary credit during partnership meetings and client communications. The most painful incident involved a major patent litigation victory. I had been working on a case for Biogenics for over a year, developing the obviousness arguments that ultimately invalidated the competitor's patents. The case went to trial, and I was part of the trial team, spending 3 weeks in federal court presenting evidence and examining witnesses. We won completely. The judge issued a ruling invalidating all asserted patents and awarding our client attorneys fees. It was a crushing victory worth tens of millions of dollars to Biogenics and a significant reputation boost for our firm. Legal publications covered the case extensively, praising the sophisticated invalidity arguments that had carried the day. In every article, press release, and client communication, Diana was credited as lead counsel. My name appeared in small font as part of the trial team if it appeared at all. Diana gave interviews to legal publications explaining her strategy and her approach to the obviousness arguments. She attended the client celebration dinner and accepted their gratitude as if she had personally conceived and executed the entire litigation strategy. When I tried to raise concerns with the firm's managing partner, Michael Katz, he gave me the same speech Diana had given. Rachel, in law firms, partners receive credit for team victories because they bear ultimate responsibility. Your work is valued internally and will be reflected in your compensation and advancement decisions. But external credit flows to partners. That's how the system works. I realized I was trapped in a system designed to exploit associates and junior partners while protecting senior partners' reputations and billing relationships. Diana had positioned herself as a gatekeeper to my success, controlling which matters I worked on, how my contributions were characterized, and whether I received meaningful recognition. Fighting her openly would mark me as not a team player and likely end my partnership prospects. But I couldn't accept systematic theft of my legal work and client relationships. I had worked too hard, created too much value, to watch Diana claim it all as her own. I made a decision. I would document everything meticulously. Every strategy I developed, every client I cultivated, every contribution I made. And when the time was right, I would present evidence that Diana's reputation was built on stolen work. I started with email evidence. Law firms generate enormous email volumes, and I had never deleted anything. I created a dedicated folder system and began organizing 16 months of correspondence chronologically. Every email where I had shared legal strategies with Diana. Every client communication I had initiated that Diana later took over. Every internal memo I had written that later appeared in her presentations with minimal changes. The email trail was damning. I found the original message where I had sent Diana my complete CRISPR obviousness strategy, attached as a 47-page memorandum. Her reply simply said, "Excellent work. Let me review and we'll discuss implementation." 3 weeks later, she presented that exact strategy at the partner meeting as her own innovation, with no mention of my authorship. I found the email chain with James Park at Neural Tech, showing 6 months of relationship cultivation before Diana ever became involved. My technical advice, my strategy recommendations, my invitations to conferences and networking events. Then Diana's separate email to James after our pitch meeting, subtly suggesting that partner-level involvement would be more appropriate, effectively cutting me out of the primary relationship I had built. I compiled billing records next. Law firms track every 6-minute increment of attorney time, creating comprehensive records of who actually worked on matters. I pulled billing data for every matter Diana claimed credit for and analyzed who had done the substantive work. The pattern was consistent. I would bill 60 to 80% of the hours on strategic development and legal research, with Diana billing minimal time until it came to client presentations and court appearances. For the Biogenics litigation, I had billed 1,200 hours on case strategy and brief preparation over 18 months. Diana had billed 300 hours, mostly for court appearances and client meetings. Yet she received 100% of the external credit for the victory. The billing records proved definitively who had done the intellectual work versus who had claimed public recognition. I documented client development activities comprehensively. Law firms track business development through CRM systems that record conferences attended, articles published, networking meetings, and client pitches. I pulled records showing my extensive business development efforts, dozens of conferences where I presented, articles I had published in legal and scientific journals, and initial contact records for clients I had brought to the firm. Then I cross-referenced those records with Diana's later claims of credit for the same client relationships. In client communications and partnership meeting presentations, Diana would characterize clients I had brought in as opportunities she had developed through her network, or secured through her reputation. The CRM data proved these claims were false. I had the initial contact records, the cultivation timeline, and the conversion documentation showing my role. I reached out confidentially to other associates and junior partners who had worked with Diana. The response was overwhelming and disturbing. 5 other attorneys shared stories remarkably similar to mine. Diana would ask them to develop legal strategies or cultivate client relationships, then claim primary credit once the work proved valuable. The pattern had been ongoing for years. Sarah Chen, a 6th-year associate specializing in software patents, described developing a claim construction strategy that Diana later presented as her own at a Markman hearing. Michael Torres, a junior partner, explained how Diana had taken over 3 client relationships he had spent years cultivating, billing herself as the primary partner while relegating him to supporting roles. Jennifer Wu, a 4th-year associate, detailed legal research she had conducted that appeared nearly verbatim in Diana's law review article, with only a passing acknowledgement in the footnotes. All of these attorneys agreed to provide written statements documenting their experiences. They were frustrated and angry, but also afraid of retaliation. Diana wielded enormous power within the firm as a name partner and member of the compensation committee. Challenging her openly could end careers. But if someone else led the challenge with comprehensive evidence, they would support it. I contacted several former associates who had left the firm, curious whether Diana's behavior had driven their departures. 3 of them confirmed that systematic credit theft by Diana had been a significant factor in their decisions to leave. One had gone to a competitor firm and immediately seen his career flourish once he was free from Diana's shadow. Another had left law entirely, so disillusioned by the exploitation that she couldn't continue in the profession. I consulted with an attorney ethics expert, Professor David Martinez from Berkeley Law School, who taught professional responsibility. We met at a coffee shop near campus, and I described the pattern of behavior without initially naming Diana or the firm. "What you're describing is a serious violation of professional ethics," Professor Martinez said after I finished. Attorneys have obligations to honestly represent their contributions and not misappropriate others' work product. In academic contexts, this would be clear plagiarism. In law practice, it violates duties of candor and honesty that are fundamental to professional responsibility. But is it actionable? Law firms have these hierarchical cultures where partners take credit for associates' work. Isn't that just how it works? There's a distinction between appropriate supervision and credit allocation versus systematic misappropriation. A partner who reviews and improves an associate's brief can legitimately share credit for the final work product. A partner who takes an associate's completed strategy and presents it as solely their own original thinking is misappropriating work product. Your description of billing records showing minimal partner contribution combined with complete partner credit suggests the latter. What remedies exist? Multiple possibilities. The firm itself may have ethics policies prohibiting this behavior. The state bar has disciplinary processes for professional misconduct. If the misappropriation involves client deception or fraud in billing, there could be malpractice implications. Civil claims for fraud or intentional interference with business relationships might be available. The key is documentation proving the pattern comprehensively. I spent 4 months organizing all of this evidence into a formal complaint. The document was 218 pages long, with exhibits including emails, billing records, client development documentation, witness statements, and comparative analysis of my work product versus Diana's later presentations. I organized it chronologically, showing the 16-month pattern across multiple matters and clients. The evidence was overwhelming. Reading through it, even I was shocked by how systematic and sustained Diana's theft had been. This wasn't occasional credit dispute or unclear attribution. This was deliberate, calculated fraud sustained across dozens of matters, stealing both intellectual work product and client relationships. I decided to present the evidence first to the firm's ethics committee before considering external bar complaints. The firm had recently implemented an ethics hotline and internal investigation process in response to broader legal industry concerns about workplace conduct. I hoped that presenting clear evidence internally might force accountability without requiring public bar complaints that would harm the firm's reputation. I submitted my complaint through the confidential ethics hotline, attaching all 218 pages of documentation. The complaint was routed to the firm's ethics committee, consisting of 3 partners from different practice groups who didn't work directly with Diana, plus an external attorney who specialized in legal ethics. 2 weeks later, I received a notice that the ethics committee would hold a hearing to investigate my allegations. Both Diana and I would have opportunities to present evidence and testimony. The hearing would be confidential, with only the committee members, the parties, and any witnesses present. I would be permitted to have personal counsel present if desired. I retained my own attorney, Elizabeth Warren, who specialized in employment and professional ethics matters. Elizabeth had previously represented associates and junior partners in disputes with law firms, with a reputation for aggressive advocacy for junior lawyers. We spent a week preparing for the hearing, organizing my presentation strategy and anticipating Diana's defenses. The billing records are your strongest evidence, Elizabeth advised during one preparation session. Billing is objective data that the firm tracks meticulously for their own business purposes. It's hard for Diana to dispute who actually billed the hours for substantive work. Combined with the emails showing you developing strategies that she later presented, it creates a pattern that's very difficult to explain away. What about her defense that partners appropriately take credit for teamwork? That works when the partner actually contributed substantively. But when billing records show the partner contributed 15% of the hours while claiming 100% of the credit, that defense falls apart. She can't simultaneously claim she did the strategic work while her billable hours prove she barely touched the matters until presentation time. The ethics committee hearing was scheduled for 3 weeks later. The time crawled by as I refined my presentation and rehearsed responses to anticipated questions. I had trouble sleeping, lying awake imagining different scenarios of how the hearing might unfold. My entire career was riding on whether the committee took my evidence seriously or dismissed it as a disgruntled associate making exaggerated complaints. The morning of the hearing arrived. I wore my most professional suit and arrived at the firm conference room 30 minutes early with Elizabeth. The room was set up with a long table for the ethics committee members and smaller tables for Diana and me on opposite sides. The atmosphere was formal and tense. The committee members filed in: Harold Chen, a litigation partner who had been at the firm for 20 years, Margaret Foster, an IP partner specializing in trademark law, Robert Kim, a patent prosecution partner, and the external ethics expert, Professor Linda Thompson from Stanford Law School. Diana arrived with her attorney, Thomas Reynolds, a prominent defense attorney from another firm. She looked composed and confident, dressed impeccably in a dark suit with minimal jewelry. She barely glanced at me as she took her seat. Harold Chen opened the hearing. This committee has been convened to investigate allegations of professional misconduct submitted by Rachel Morrison regarding Diana Fletcher's attribution of legal work product and client relationships. Ms. Morrison, you will have up to 2 hours to present your evidence and testimony. Ms. Fletcher will then have equal time to respond. Both parties may have counsel present but cannot interrupt the other party's presentation. Afterwards, the committee will ask questions. I stood and walked to the presentation area where I had set up my laptop connected to a large screen. My hands were shaking slightly, but my voice came out steady. Members of the committee, thank you for convening this hearing. What I will present is evidence of systematic misappropriation of legal work product and client relationships over a 16-month period. This is not a dispute about unclear credit allocation. This is documented, deliberate theft of intellectual work and professional relationships that has built Ms. Fletcher's reputation while erasing my contributions. I started with the CRISPR litigation strategy, displaying my original 47-page memorandum sent to Diana dated 18 months ago. I showed the email where I presented it to her, explaining that I had spent 3 months developing the approach. Then I displayed the transcript from the partner meeting 3 weeks later where Diana presented her innovative approach to obviousness arguments, describing work she claimed to have spent months developing. Note the language, I said, highlighting key passages. Ms. Fletcher claimed to have spent months developing this strategy, conducting molecular biology research, and consulting with experts. The timeline proves this is false. I sent her the complete strategy 3 weeks before her presentation. The only months of work that occurred were mine. I moved to billing records next, displaying a chart showing the biogenics litigation. Over 18 months, I billed 1,200 hours on this matter, primarily on strategy development and brief preparation. Ms. Fletcher billed 300 hours, primarily on court appearances and client meetings. Yet in every external communication, article, and press release, she was identified as lead counsel who developed the winning strategy. I played portions of a video interview where Diana discussed her approach to the case, using technical language and arguments I had developed, presenting them as products of her own legal thinking. The committee members were taking extensive notes. Professor Thompson interrupted with a question. Ms. Morrison, in your email sending Ms. Fletcher the legal memorandum, did you characterize it as final work product or as a draft seeking her input? I characterized it as my completed strategic analysis, sent for her review before implementation. The email specifically stated, I've completed my analysis of the obviousness arguments and believe this approach will be successful. There was no request for her to develop or refine the strategy further, only to approve implementation. I continued through client relationship documentation, showing 6 months of cultivation efforts with Neuraltech followed by Diana's last-minute insertion as primary partner. I displayed CRM records proving I had initiated contact, conducted technical consultations, and positioned the firm as preferred counsel, only to have Diana take over the billing relationship after I had done the work of conversion. The pattern is consistent across 5 major matters and 3 significant client relationships, I concluded. In each case, I developed the strategy or cultivated the relationship, shared it with Ms. Fletcher through appropriate channels, and then watched as she presented it externally as her own work. The billing records, emails, and CRM data prove this pattern beyond dispute. I presented the witness statements from 5 other attorneys describing similar experiences. This is not isolated to me. Multiple attorneys have experienced identical patterns of having their work appropriated by Ms. Fletcher. Some left the firm because of it. Others remained silent out of fear of retaliation. But the pattern is unmistakable. My presentation ran 1 hour and 47 minutes. When I finished, Harold Chen thanked me and asked Diana to present her response. Diana stood and walked to the presentation area with the confidence of someone who had argued before federal judges for decades. She began by characterizing my complaints as a fundamental misunderstanding of law firm economics and partnership dynamics. I want to start by acknowledging that Rachel Morrison is a talented attorney, Diana said, her voice measured and professional. She has produced excellent work product during her time at this firm. But what we're seeing here is a young associate who doesn't yet understand the distinction between technical legal work and the strategic judgment, client management, and risk assessment that partners provide. She clicked to her first slide, showing firm organizational charts and explaining partnership structures. In law firms, associates and senior associates perform crucial legal research and analysis. Partners synthesize that work, apply strategic judgment based on years of experience, interface with clients at decision-maker levels, and bear ultimate malpractice liability for outcomes. This hierarchical structure isn't exploitation. It's how legal expertise develops through mentorship and progressive responsibility. Diana addressed the CRISPR strategy specifically. Rachel did prepare an excellent legal memorandum analyzing obviousness arguments. That memorandum was valuable research. But translating research into viable litigation strategy requires partner-level judgment about timing, presentation, client risk tolerance, and tactical positioning. I reviewed her work, refined the arguments, assessed the strategic risks, and determined how to implement the approach effectively. My contribution wasn't minor editing. It was strategic transformation of research into actionable legal strategy. The billing records Ms. Morrison presented actually support my position, Diana continued, clicking to a new slide. She billed primarily research and drafting time. I billed client consultations, strategy sessions, and court appearances. Those different time categories reflect our different roles. She performed technical work, which is valuable. I performed strategic work, which is essential to converting research into client value. Both contributions matter, but they're not equivalent. She addressed the client relationship issues next. Regarding neural tech and other client relationships, Ms. Morrison is again conflating different roles. Associates attend conferences, network with potential clients, and make initial contacts. These activities are valuable business development contributions. But converting those contacts into actual engagements requires partner-level commitment. Companies hiring patent counsel want to know a partner will be accountable for their matters, not just available for technical support. When James Park at Neuraltech expressed concerns about having appropriate partner attention, I stepped in to provide that assurance. That's not stealing a relationship Ms. Morrison developed. That's fulfilling the partner role of client service leadership that made the engagement possible. She still works on neural tech matters and receives appropriate credit internally through her compensation. Diana's presentation was polished and superficially persuasive. She was reframing systematic theft as appropriate division of responsibilities, using law firm cultural norms as justification. But I noticed she wasn't addressing the specific evidence. She wasn't explaining why she claimed to have spent months developing the strategy I sent her 3 weeks before her presentation. She wasn't addressing the witness statements from multiple attorneys describing identical patterns. Margaret Foster raised her hand. Ms. Fletcher, I'd like to focus on specific factual claims. In your presentation at the partner meeting 18 months ago regarding the CRISPR obviousness strategy, you stated, and I'm reading from the transcript, I've spent the last several months developing this approach, conducting molecular biology research and consulting with experts. Can you explain that statement in light of Ms. Morrison's evidence that she sent you the completed strategy 3 weeks before your presentation? Diana's composure wavered slightly. The transcript may not fully capture the context. I was speaking about the broader strategic development of our CRISPR practice, not solely that specific legal argument. Over several months, I had been thinking about how we approach CRISPR patents generally. But you also said, Margaret continued, reading from the transcript, this specific approach to combining prior art references using statistical analysis of publication patterns. That's very specific technical methodology. Was that methodology something you developed or something Ms. Morrison developed? The detailed methodology was part of Ms. Morrison's research contribution. I was describing the overall approach, which incorporated her research among other elements. The transcript doesn't support that interpretation, Professor Thompson interjected. You presented the methodology as your own development. The language is clear. Either the transcript is inaccurate, or you misrepresented your contribution. Diana's attorney, Thomas Reynolds, spoke up. The committee should focus on overall patterns rather than parsing individual word choices in informal presentations. Partnership attribution is inherently imprecise, and different audiences interpret contributions differently. Harold Chen shook his head. Mr. Reynolds, precision about contributions is fundamental to professional integrity. If Ms. Fletcher explicitly claimed to have personally developed methodology that Ms. Morrison actually developed, that's misrepresentation, not imprecision. Diana continued her presentation, but the committee's skepticism was increasingly apparent. When she addressed the billing records, claiming they reflected appropriate division of labor, Robert Kim interrupted. Ms. Fletcher, I've reviewed the billing breakdown carefully. On the biogenics litigation, Ms. Morrison billed 80% of the substantive legal work hours. You billed mostly court appearances and client meetings. Yet every external communication identified you as lead counsel who developed the winning strategy. How can you be lead strategist while contributing only 20% of the strategic development hours? Court appearances and client management are where strategy matters most, Diana replied. Anyone can draft a brief. Presenting arguments persuasively to judges and managing client expectations requires experience and judgment that justifies lead credit. That's a concerning characterization, Professor Thompson said. Are you suggesting that the extensive legal research and brief drafting Ms. Morrison performed was trivial work that anyone can do? Because that directly contradicts your earlier statement that her work was valuable and sophisticated. Diana realized she had made an error. I didn't mean to imply her work was trivial. I meant that different types of work require different levels of experience. The hearing continued for another 40 minutes, with the committee systematically dismantling Diana's explanations. Her defenses were inconsistent, alternating between claiming her contributions were substantial and minimizing the importance of the work she admitted I had done. She couldn't adequately explain the witness statements from multiple attorneys describing identical patterns. She couldn't address the specific false statements about timelines and contributions. When Diana's presentation concluded, Harold Chen announced the committee would deliberate for 3 hours before reconvening with preliminary findings. Diana and I were dismissed to separate conference rooms to wait. The waiting was excruciating. I sat with Elizabeth in a small conference room, unable to focus on anything. My legal career was in the balance. If the committee sided with Diana, characterizing my complaints as misunderstanding of law firm culture, I would be finished at Morrison and Fletcher and likely blackballed from other firms as someone who couldn't work within standard hierarchies. At 5 o'clock, we were called back to the hearing room. All 4 committee members were seated with serious expressions. Harold Chen held a typed document. The committee has completed its preliminary review of the evidence and testimony presented. Our findings will be submitted to the managing partner and full partnership for final decisions on disciplinary action, but I will share our conclusions with the parties present. Diana sat rigid in her chair, her face pale. First, regarding attribution of legal work product. The evidence establishes that Ms. Fletcher systematically misrepresented her contributions to legal strategies developed primarily by Ms. Morrison and other associates. The billing records, emails, and specific false statements about development timelines demonstrate a pattern of misappropriation inconsistent with appropriate supervisory credit sharing. The committee finds these actions constitute professional misconduct. Diana's attorney started to speak, but Harold held up his hand. Second, regarding client relationships. The evidence shows Ms. Fletcher took over client relationships Ms. Morrison had cultivated, positioning herself as primary partner after conversion work was complete. While partners may appropriately claim client management roles, the pattern here reflects misappropriation of business development credit rather than appropriate role differentiation. This violates the firm's business development attribution policies. Third, regarding witness testimony. Statements from 5 attorneys describing identical patterns of work appropriation establish this is not isolated to Ms. Morrison but reflects systematic behavior over multiple years. Several attorneys left the firm due to Ms. Fletcher's conduct, representing significant economic harm to the firm through lost talent. The committee's recommendations are as follows. Ms. Fletcher should be stripped of name partnership status and removed from all firm leadership committees. Clients she claims primary credit for should be contacted to clarify actual attorney contributions, with billing relationships adjusted appropriately. The firm should conduct a comprehensive review of all matters Ms. Fletcher has billed on to identify and correct attribution errors. Consideration should be given to termination of partnership depending on managing partner and partnership vote. Diana stood abruptly. This is absurd. I've built this firm. I've brought in millions in revenue. You're destroying my career based on complaints from junior associates who don't understand partnership economics. Harold's voice was firm. Ms. Fletcher, the evidence presented is overwhelming. You made specific false statements about your contributions that billing records definitively contradict. You've systematically claimed credit for work product you didn't create. This isn't about partnership economics. It's about professional integrity and honesty, which are non-negotiable regardless of revenue generation. Professor Thompson added, I'll also note that your conduct creates potential bar discipline exposure. Misrepresenting contributions to clients could constitute fraud. Claiming credit for work product you didn't create violates duties of candor. I'd recommend you consult with personal counsel about potential disciplinary proceedings. The hearing was adjourned. Diana left quickly with her attorney, not looking at anyone. I remained seated, barely processing what had happened. The committee had sided with me completely. Diana's career at the firm was over. The managing partner, Michael Katz, called me into his office 2 days later. Rachel, the ethics committee's findings were comprehensive and damning. The full partnership met yesterday, and we voted to terminate Diana's partnership effective immediately. Several clients she claimed primary relationships with have indicated they want you as their primary attorney, which suggests she had been misrepresenting her role to them as well. What happens now? I asked. We need to rebuild trust internally and with clients. We're offering you early promotion to partner, effective in 3 months, with a compensation package reflecting the client relationships and matters you should have been credited for all along. We're also implementing new policies on work product attribution and business development credit to ensure this never happens again. The promotion was gratifying but bittersweet. I had earned partnership through my work, but I had lost 2 years watching someone else claim my achievements. Still, justice had prevailed, and the firm was taking accountability seriously. Diana's departure from the firm was swift and comprehensive. She cleaned out her office in 2 days, escorted by security due to concerns about client file access. The firm sent letters to all clients she had worked with, explaining the partnership termination without detailing the reasons but offering alternative counsel arrangements. Multiple clients immediately requested that I become their primary attorney, validating that I had been the one providing substantive value all along. Diana attempted to join another firm, but word spread quickly through San Francisco's tight-knit IP legal community. The ethics committee findings weren't public, but enough partners knew the circumstances that Diana's reputation was destroyed. No firm wanted to hire a partner with documented evidence of systematic work appropriation and potential bar discipline exposure. 6 months after her termination from Morrison & Fletcher, I heard through the legal community that Diana was facing state bar disciplinary proceedings. Several former clients had filed complaints after discovering the extent to which she had misrepresented attorney contributions on their matters. The bar investigation confirmed the pattern of misconduct, and Diana's law license was suspended for 2 years. Without her license and reputation destroyed, Diana left legal practice entirely. I heard she attempted consulting work, but even that dried up as her story spread. The last I heard, she had moved out of California entirely, trying to rebuild some kind of professional identity in an unrelated field. For me, the years following Diana's termination brought tremendous professional growth. As a partner at Morrison & Fletcher, I rebuilt my practice with proper attribution and credit. The clients who transferred to me were incredibly loyal, grateful to finally work with the attorney who had been providing strategic value all along. My practice grew rapidly, and I became one of the firm's top revenue generators within 2 years. But I also felt constrained by the firm's history. Morrison and Fletcher would always be associated with the dysfunction that had enabled Diana's behavior for years. 3 years after becoming partner, I made the decision to leave and start my own boutique IP firm focusing on biotech and neurotechnology clients. I founded Morrison IP Law with 3 other partners who had also experienced credit appropriation issues at larger firms. We built the firm on principles of transparent attribution, equitable billing relationships, and genuine mentorship rather than exploitation. We implemented policies requiring clear documentation of who developed strategies, who cultivated clients, and how credit would be allocated before matters began, eliminating the ambiguity that enabled theft. The firm grew quickly. Clients appreciated the transparency and knowing exactly which attorney was providing which value. Associates and junior partners wanted to work with us because we had demonstrated commitment to proper attribution. Within 5 years, Morrison IP Law had 40 attorneys and was regularly competing with much larger firms for sophisticated patent work. I also became an advocate for reforming law firm culture around attribution and credit. I published articles in legal journals about exploitation of junior attorneys and the need for structural changes to partnership models. I spoke at law schools about documentation practices and protecting your work product in collaborative environments. My experience with Diana became a case study in legal ethics courses, illustrating how power differentials enable misconduct. 10 years after the ethics hearing that ended Diana's career, I testified before the California State Bar's Commission on Professional Ethics about reforming rules around work product attribution. I presented data showing that junior attorney exploitation was widespread across law firms, with surveys indicating over 50% of associates had experienced credit theft at some point. My testimony contributed to new mandatory disclosure rules requiring firms to clearly communicate authorship of significant legal strategies to clients. I received numerous professional recognitions, including the California Lawyers Association's Ethics in Practice Award and the IP Section's Distinguished Service Award. These honors validated not just my legal work but also my fight against the system that had enabled Diana's theft. Each recognition felt like vindication for the terrifying decision to file that ethics complaint and risk my career for truth. My personal life also flourished in unexpected ways. I met my wife, Dr. Jennifer Park, at a biotech conference where I was speaking about patent strategy. She was a neuroscientist working on brain-computer interfaces, brilliant and passionate about translating research into clinical applications. We married 2 years after meeting, creating a partnership based on mutual respect and shared commitment to innovation. We had twin daughters, and I discovered I could balance legal practice with family life through intentional choices and strong boundaries. Diana's trajectory remained dismal. Her law license was eventually reinstated after the 2-year suspension, but she never practiced again. The documented misconduct made her unhireable, and attempting to start a solo practice failed when potential clients searched her name and found articles about the ethics proceedings. She faded from the legal community entirely, a cautionary tale discussed in hushed tones at Bar Association events. Looking back on those 16 months of theft and the decision to fight back, I'm grateful for several things. First, that I had the discipline to document everything comprehensively. Without the emails, billing records, CRM data, and witness statements, my allegations would have been dismissed as one person's word against an established partner. The evidence made denial impossible. Second, that the firm had implemented an ethics hotline and investigation process that allowed concerns to be raised confidentially. Many firms lack such mechanisms, forcing junior attorneys to either accept exploitation or make public complaints that end careers. The internal process gave me a path to accountability without immediately destroying my professional future. Third, that I trusted my judgment about right and wrong rather than accepting toxic cultural norms. Multiple people told me that credit theft was just how law firms worked, that I should accept it and focus on internal compensation rather than external recognition. Refusing to accept that narrative, insisting that systematic fraud was wrong regardless of how common it might be, was essential to fighting back effectively. The 72 hours between filing the ethics complaint and the hearing were the most terrifying of my professional life. I nearly withdrew the complaint dozens of times, convinced I was committing career suicide. But I had created something remarkable through years of training and work, and I refused to let someone else claim it as their own. To anyone reading this who has had their work stolen in legal practice or any professional field, who has watched someone else claim credit for your strategies and relationships, who has been told this exploitation is normal. Document everything. Every email, every work product, every business development activity, every conversation. Build an irrefutable trail of evidence. And when the moment is right, present it to people with the authority and integrity to act. Diana Fletcher spent 16 months building her reputation on my stolen legal strategies and misappropriated client relationships. It took me less than 2 hours to dismantle that reputation completely with evidence she couldn't refute. The truth, when properly documented and presented to people who care about professional integrity, is devastatingly powerful. And that is how you get revenge.